Good morning, everyone. Honourable Deputy Minister Bhuti Manamela, Honourable Chairperson of the Portfolio Committee of Trade and Industry, Ms. Joan Marie Fubbs, the Acting Deputy Director General, Mr. MacDonald Meshendri, professors, speakers, delegates, stakeholder representatives present here, members of the Media House, distinguished ladies and gentlemen, I welcome you. It is almost 2 years that have passed since the publication of the 2015 Copyright Amendment Bill on the 27th of July for wider public consultations. After numerous consultations and processes and applying government policy objectives in an inclusive and balanced manner, I am pleased to confirm that the two pieces of legislation are before the Parliament of South Africa for consideration: the Copyright Amendment Bill of 2017 and the Performance Protection Amendment Bill of 2016. Initially, the amendment to the Copyright Act was based on the challenges facing the music sector as a result of the presidential meeting of 2009, where all key government departments were mandated to address these problems. As a result, the 2011 Copyright Review Commission report published a detailed report with recommendations to alleviate the plight of the musicians. As the DTI began to unpack the legislation, we realized that issues contained in the legislation were severely outdated. It soon became apparent that the copyright-based industries in South Africa were all struggling, and that in some ways copyright was a barrier rather than an economic tool. And so the DTI embarked on a process of reform based on fairness, balance, transparency, and accountability. As you've heard several times today, this is a balancing act of many competing interests, challenging the status quo and reforming the law, and I want to emphasize the next few words, on an access-oriented legislation, creating legal certainty. I know there are some stakeholders who may not agree with the proposed reform, but many stakeholders do, and many of you have been part of the process since the publication of the 2013 Draft Intellectual Property Policy, which was also a manner of consultation on the domain of copyright. I just want to take you through the new changes in the bill. Notably, the biggest change is that there are two bills before Parliament, one dealing with copyright proper issues and one dealing with related rights, as opposed to the 2015 bill, which meshed all issues together. The definition of craft works was removed, as advised by you, the stakeholders, because the Principal Act covers the definition and the protection of artworks. And we also removed the provision that state copyright would be perpetual. I will briefly discuss the topical amendments contained in the amendment bills. It must be noted that South Africa's current Copyright Act and Performance Protection Act do not provide right holders any digital exploitation rights. There's nothing in the current legislation. So the bill introduces clear provisions relating to collective management as recommended by the Copyright Review Commission. The bill establishes one collecting society per copyright set of rights, and not one powerful collecting society, which has been the misrepresentation. All collecting societies will be regulated by the Companies and Intellectual Property Commission, and collecting societies will only be allowed to collect for their registered members to avoid the unallocated revenue of being distributed to those who are not worthy of those payments. An empowering provision in the bill allows for the Minister of Trade and Industry to develop minimum contractual standards as requested by industry. This will not be limited to the music sector, but the entire creative industry, to ensure that intellectual property rights are not signed away perpetually, and to ensure minimum standards of protection as allowed in contract law are concluded in these contracts. The Presidential Task Team is also spearheading the contracts in terms of the audiovisual sector. The Copyright Amendment Bill is also very clear on the 50% split between the recording company and the performer. The amendments include clear provisions which make the law ready to ratify or accede to several key treaties in the domain of copyright and related rights. The World Intellectual Property Internet Treaties, the Copyright Treaty, which deals specifically with copyright protection in the digital environment, and the Performers and Phonograms Treaty, which grants performers 4 kinds of economic rights, namely the right of reproduction, distribution, rental, and making available. Obviously, one risk of implementation of these rights is a possible imbalance of public and private rights. However, this can be mitigated through the crafting of a very careful fair use or fair dealing provision to ensure user rights to access. The bill has done this, which I will discuss shortly. Accession to the very important Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. However, the bill extends the scope of this treaty to the broad variety of disabilities. The bill clearly defines these disabilities and what is meant by accessible formats. The Beijing Treaty on Audiovisual Performances, which regulates copyright for audiovisual performances and expands performers' rights. The Performers Protection Bill, in addition to these economic rights, grants audiovisual performers with the all-important moral rights. The Performers Protection Bill entrenches the right to repeat fees for the commercial exploitation of audiovisual work. And lastly, the Rome Convention dealing with the needle-type royalties. The Copyright Amendment Bill introduces many accepted international exceptions and limitations, but the most widely debated is the fair use provision. There is enough research and academic opinion on whether or not fair use and fair dealing are the same. The bill introduces an access-oriented fair use provision and supports an open access clause. Many developing countries are opting for an open fair use provision. Despite some opinions that will harm industry, no evidence as such has been provided to the DTI. Research shows the contrary view. I'm sure other speakers will discuss this further in the spirit of the roundtable and debates around the fair use provision. The debates, however, need to graduate from whether South Africa is following the US doctrine for opting for a fair use provision, or if we're dealing with the UK Hargreaves report, which is very against fair use. There is a constant need for the intellectual property system to adapt to new forms of innovation, creativity, and technology. These developments can pose threats to the effective copyright regime, unless the legislation is able to adapt appropriately. With trips to Mars not far off and the fourth industrial revolution, it is important that the legislation supports the spirit of adaptability. Fair use provides a legal mechanism where the courts can legitimize the application of technology. As I mentioned, the bills are access-oriented, and this means that all stakeholders should have access to redress. The current copyright tribunal has been limited in many ways. Judgments are not made speedily, and not everyone has access to the system. The bill introduces a tribunal system based on the Companies Law Tribunal. The new tribunal will play an important role in the determination of fair royalties that are market-related to avoid the current situation where the tariff set by the court is one of the lowest in the world for needle time. Other issues in the bill: state-owned intellectual property. Here the message was unfortunately lost in translation. The aim of the provision is access. In terms of the Constitution, intellectual property is considered to be property, and in terms of the PMFA, the state has to keep an adequate record of its property. So the intention is for the state to grant access to its copyright works for the economic advantage of its citizens. The wording of the bill is also as a result of consultation, but these matters will be discussed at the public hearings. Protection of orphan works, although the view is that the process is cumbersome as provided in the bill, and in the absence of an international solution, the bill proposes a solution to the protection of orphan works. Here again, the state is meant to be seen as a guardian, protecting the orphan works and allowing access and protecting the user from redress should the owner resurface. The bill also allows for parallel importation through an international exhaustion regime. The bill introduces many provisions on technological protection measures. The bill further introduces a resale royalty for artistic works, with the rate to be determined by the Minister in consultation, or after consultation rather, with the Minister of Arts and Culture. And last but certainly not least, local content. The bill deals with the local content quotas, but it allows for the Minister of Trade and Industry, after consultation with his counterpart in communications, to establish a local content quota. In conclusion, copyright is not an absolute right. It is not only limited by the Constitution, by the Paris and Berne Conventions, of which South Africa is a party. Copyright arguably has the biggest group of stakeholders. Therefore, there are many competing interests. If the legislation is not updated and made clear, certain competing interests will cause the current imbalance to remain, and copyright regime will continue to hamper access, and those artists who we are trying so hard to protect will die as paupers. All affected stakeholders and government need to work together to ensure the transition is balanced and that certain digital legislation is actually acceded to, and that we update this act as 1978 legislation. We want to avoid the mistakes that we've made in the past, such as the 2002 amendment, which was exploited in not paying the royalties. We want to ensure that the copyright industry does benefit and that it grows, because it's been proven in the USA that when they were in a recession, the copyright industry still grew. I would like to wish Parliament well with its deliberations. I'd like to thank each and every one of the stakeholders here for debating the bill on a continuous level and for keeping the dialogue open. And I'd also just like to thank Bridget very much for this wonderful event that she's organized, and the partners, Google and the Freedom of Expression Institute. Thank you very much for the forum that we have here today, and I trust that the engagements will be very fruitful. Thank you.